Well, yeah, once it, I don't know how to get it there. Oh, I know all this. Well, I just have the, the Zoom, what do you call it, icon. You can go right into that. If you can get them to send an email. I'll show you when I'm done. If you send an email to my email, then you can just look into that. Okay. Maybe I can forward it to you. Yeah, you can do that. And then when you get there, you just keep clicking, Morning, Sherrod.
Good morning, Your Honor.
Morning, Judge. How are you?
Morning.
Timothy Watts here.
Yes, okay. Okay. All right, looks like, I guess this is everyone. All right, we will, call cause number CR24-106, State of Texas versus Bruce Lynn Jackson. This defendant's motion for new trial and arrest of judgment being held via YouTube in order to comply with it, and being held by Zoom and broadcast over YouTube in order to comply with the open courts doctrine. And I'll note that Mr. Jackson is present, as well as Mr. Muralidhar and Mr. Watts. And at this time, then Mr. Muralidhar, was state ready to proceed?
Timothy Watts present on behalf of the state, Your Honor. We are ready to proceed.
Muralidhar, are you ready to proceed?
Yes, sir. Shroff Muralidhar for the defendant and appellant, Mr. Bruce Jackson. We're ready to proceed, Judge.
All right, and I will note further, Mr. Muralidhar, I have received your exhibits this morning consisting of the judgment of conviction and waiver of jury trial by the court, the indictment, and state's pretrial notice of experts, witness list, and other matters. Is there any objection from these of these exhibits from the state?
No, Your Honor.
All right, each will be received. And Mr. Muralidhar, you may proceed with your motion.
Thank you, Judge. I am not asking for Mr. Jackson to testify, so this is purely going to be on the exhibits and the court's filings that we made. In addition, Judge, we would ask the court to take judicial notice of the court's file and its contents as well.
Any objection, Mr. Watts?
No, Your Honor.
All right, the court will take judicial notice of the contents of the court's file.
So, Judge, my motion is two-part. In the first issue, I allege that the state failed to prove the enhancement that they used at trial. The enhancement that they used at trial is the judgment of conviction for the DWI third or more case that you have. I would ask that the court mark that as Exhibit 1 or Defense Exhibit 1. And in that case, they used his name, I guess state ID, the cause number, the information contained on the judgment, and a partial fingerprint to confirm that it was him for the purposes of presenting information to the jury for enhancement.
Let me state for the record, I have marked, the court has marked DEF, defendant 1 on this judgment. All right, go ahead, Mr. Muralidhar.
Thank you, Judge. And if the court recalls, this was the only enhancement that was used. And if it was not proven, the punishment range would have been 2 to 20. And if the jury found it to be true beyond a reasonable doubt, the enhancement becomes 5 to 99 or life. And the jury found it to be true, and they sentenced Mr. Jackson to 30 years. From the case law that I've been reading, Judge, it's clear that there is not one specific thing that is particularly needed to prove up a judgment. Essentially, in that Flowers case, the state must prove beyond a reasonable doubt that a conviction exists and that the defendant is linked to that conviction. It's going to be a jury question as to whether or not they believe that it was the same exact person. From what I know about the trial evidence, there was no other evidence included aside from just this document and the state's expert saying that it was him regarding the partial fingerprint. I do not believe that that's sufficient to prove the conviction. Furthermore, I don't believe that Mr. Jackson received proper notice for the actual conviction. In the state's pretrial notice of experts, witness list, and other matters, which was filed on April 1st, 2024, I would ask that to be marked as defense 2.
All right, and the court will mark that as defense 2.
In that, Judge, there is no specific mention of the DWI. In enhancement cases, the state is not required to show the specific cause number or the specific offense, cause number or Texas Penal Code section, but they do need to provide some notice to the defendant to show that it was this prior conviction that they're going to use for enhancement. In the motion that was used for the state, I didn't see any other Brooks notice or any other notice in the file that was in on the state's discovery. So I apologize if there's something in the clerk's record or something in the court's file that actually shows the actual DWI as the Brooks notice. But as far as I can tell, this was the only notice to show for prior enhancement. And I believe this is insufficient for enhancement as far as a Brooks notice. All it says on page 2 is the state's notice of intention to use extraneous offenses and prior convictions, and they just point to the discovery for prior offenses that they might use. They don't specifically list this DWI, the year, which county was conducted. Again, they don't need to show all these things specifically, but they do need to provide some notice to the defendant about the prior enhancement. So I believe that's insufficient as well for the enhancement.
All right, let me note, Mr. Muralidhar, as a content of the file, the court is looking at a file state's notice to intent to seek higher punishment, filed June 16, 2024. Brooks, which is what we all refer to as a Brooks notice. And it does reference in that case, or in that notice, of a prior to commission of aforesaid offense on 16th day of May 2013, cause number 1303-202-895 CR in the 9th District Court of Montgomery County. Defendant was finally convicted of a 3rd-degree felony offense of driving while intoxicated, 3rd or more. I'll just note that.
All right, then I'll withdraw that argument, Judge. I just I did not see that on the online discovery. Again, that's not a complete amount of stuff that's filed into the case. So that's my.
But that, and also for the record, I will note that does not reference the judgment of conviction that was entered. What? Or yes, it does. I'm sorry, it does too. I was mistaken. All right. So that does reference it. Okay.
Okay. Yeah. In that case, Judge, I'll withdraw that that part of the argument. And then finally, Judge, the indictment on my second reason for the motion for the new trial, I would ask that the court admit this as a defense 3.
All right, and I'll mark it and be admitted defendant 3.
And in the indictment, if you follow near the end, it says hereinafter style the complainant by hitting said complainant in the head with a heavy duty flashlight. At trial, I don't believe there was any evidence adduced about the weapon being a heavy duty flashlight. The state put this in the indictment as notice of the defendant and included this as an additional element of the offense. If this additional element was not proven, we believe that that's insufficient to prove the allegations as listed in the indictment. And for those reasons, Judge, we're asking for a new trial.
All right, Mr. Watts.
Thank you.
I want to note, if I fail to do so, Mr. Jackson is appearing by Zoom. Okay.
Yes, sir.
All right, go ahead, Mr. Watts.
Thank you, Your Honor. It's the state's position on this matter that that we provided sufficient Brooks notice to the defendant in order to enhance his punishment. And then during the proceedings, we offered our investigator to testify, who provided testimony regarding the identifiers that were contained on the conviction used for enhancement, and he was able to connect those identifiers with the defendant at trial. And when the jury heard that, they sided with our investigator and determined that this defendant was the person named in the offenses that were used against him on the Brooks notice. So I believe the state provided sufficient evidence to connect him to the offense that was being used to enhance his sentence. And in regards to the flashlight issue, I believe that the state provided sufficient evidence at trial that the flashlight was the type of flashlight that was capable of producing the damage that was alleged in the case, that it was a type of flashlight that could result in bodily injury to the officers. The officers testified as to what happened to them, what they observed. So I believe that the state provided sufficient evidence at trial to prove the allegations that were made in the indictment, including that the flashlight used was heavy duty.
All right, Mr. Muralidhar.
Nothing further, Judge.
All right. All right, based on the evidence before the court as well as the contents of the file, the court denies the motion for new trial. And I do have an order, I think, in the file. Maybe I do not. All right, the state will provide the court with an order.
I can email the court an order right now. I'll send that to your coordinator, Judge.
All right, thank you, Mr. Muralidhar.
Yes, sir.
We'll stand in recess in these matters.
Thank you.